Hi, everyone. Thank you for joining us today for Constangy's webinar, Protecting Off-Duty Cannabis Use in California, What Employers Should Know. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. This program is approved for Sherman HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Kia, Ashley, and Carolyn.
Thank you, Victoria. Appreciate it. So, good afternoon or good morning, everyone, depending upon where you are in the country. My name is Kia Denner, and we're going to kick off our presentation today, which is about protecting off-duty cannabis use in California, specifically in light of the new AB 2188, which is the new law that just took effect on January 1st, 2024. So I'm going to start out today. We're going to do a little bit of an introduction, kind of do a overview of where we are in terms of cannabis regulation for employers across the country and on the federal level. And then I'm going to turn it over to Carolyn. She's going to talk about California's new law. And then Ashley is also going to speak about a similar law that just took effect in Washington State. And then we're going to kind of wrap it up with best practices for employers, specifically in California and Washington, but also, across the country, especially if you're a multi-state employer. So that, get right into it. So cannabis employment laws, where are we on a federal level and on a level in terms of across the states, the 50 states? Medical cannabis, we're up to 38 states now, including District of Columbia and some of the U.S. territories there. 20 of those provide some form of statutory employment protection for employees who use medical cannabis. And what I mean by that is that those are embedded in their state statutes, right? So their medical cannabis laws, they will have some explicit employment protection for cardholders. Keep in mind, there could be other jurisdictions, for example, like Massachusetts and New Hampshire, where there are some employment protections potentially for medical marijuana users, and that would be via the state disability discrimination laws, for example. But I didn't include those in the 20. Those 20 are just statutory protections that are usually right there in the medical marijuana statute. And then on the recreational or the adult use side, we have 24 states now, including Washington, D.C., and I've listed those for you that have adult use or recreational cannabis. And then we have, I think the last time I counted, we're at nine states: California, Connecticut, Nevada, New Jersey, New York, Rhode Island, Minnesota, Montana, and Washington State, who in their adult use or recreational cannabis laws have employment protections for people who use recreationally off duty. And today, as I mentioned in our intro, we're going to talk specifically about California first and foremost, and then we're also going to talk a little bit about Washington State. And those are the two states where, earlier this month, January 1st to be exact, we have these employment protections that take effect. So that's on the state side, right? So on the federal side, let's take a few minutes, just talk about, where we're at. It's marijuana or cannabis is currently still a Schedule I drug on the according to the Controlled Substances Act. Okay, so that means it's treated the same as pretty hardcore drugs: heroin, LSD, ecstasy. It's on Schedule I. That means technically it has no known medicinal value, and it has a high potential for abuse. That's the criteria to be on Schedule I of the CSA. This is the domain of the DEA. They, they are the keepers of the schedule, so to speak. So currently, that's where we are, Schedule 1, federal law. In a few minutes, we'll talk about how that may change in the near future. But before we do that, I'm going to just turn back the clock a little bit and kind of just give a little bit of a history here. I like to start in 2008 because on the federal side, that's where things have started to change in our recent history. I can't believe it's already been 6 years ago is 2018. But in 2018, that is when the FDA, federal agency, approved a drug formulated to treat childhood epilepsy. And that drug used cannabis. It was derived from CBD, derived from the cannabis plant. So it wasn't a synthetic. It was actually right from the plant. And in response to that, the DEA rescheduled that particular drug to Schedule 5. So remember what I said a minute ago, to be on Schedule 1, it has to have no known medicinal value. So I start here because this is that spot where you have a federal agency, in effect, recognizing that there is some medicinal value. Later that year, we then had another important event, the Hemp Farming Act of 2018, which legalized industrial hemp. So that is no longer illegal under federal law. Talk a little more about industrial hemp in a second. And then, starting in 2020, you start to have a whole wave of legislation that comes out of committees, gets onto the floor of either the House of Representatives or the Senate. And these are bills to essentially decriminalize marijuana on the federal level. This is noted. Now, of course, none of these bills have passed both houses, but it's notable here because 10, 15, 20 years ago, this type of legislation was not even getting out of a committee. So it's notable that, we've seen, much progress in that arena. Whether or not we'll ever get there on the federal level to decriminalize fully, who knows? That's a political question, but it is notable, and it really kind of backs up the change that we've been seeing in the states over the last 15 years, such that we have it to currently we have 38 states that have medical marijuana. And then this slide also shows, just kind of the most recent, history here, where we've had New Jersey, New York, Virginia, New Mexico, Connecticut. Those all came line with recreational in 2021. And then last year, Minnesota legalized adult use as of August, and they also added some employment protections into their law. And then, of course, California and Washington, who already had recreational cannabis, but now they have employment protections as of January 1st, 2024. I want to talk for a minute about President Biden's directive to HHS, Health and Human Services, in 2022. At the end of 2022, he did this in connection with pardoning all federal offenders convicted of simple marijuana possession. But in addition to that, he directed HHS and the Attorney General to basically review whether or not cannabis should still be a Schedule 1 drug under the CSA. Last year, at the very end of August and heading into September, HHS finally made their recommendation, and the recommendation was to reschedule cannabis from Schedule 1 to Schedule 3. They did that in a letter, August 29th. And since that time, we've basically been kind of, monitoring what's going to happen. As I mentioned a minute ago, the DEA is the federal agency that makes this determination. The HHS makes the recommendation. Based on my research, I don't think DEA has ever not followed an HHS recommendation with respect to scheduling or rescheduling of a drug. Sometimes, though, it takes years. So what has been happening basically since August is you've seen a lot of campaigning going on. So, for example, I read just yesterday, you had a group of 10 senators writing to the DEA, basically lobbying to say, you shouldn't go to Schedule 3. You should actually deschedule it altogether. And then on the flip side, you have other groups, former DEA drug czars, for example. You have former attorneys, states attorneys generals, or federal prosecutors, writing letters stating the opposite. Keep it at Schedule 1. So there's been a lot of political lobbying going on, depending upon which side of the fence you fall on this question. And we'll see what happens. But my prediction, I think this determination gets made sometime in 2024. And it's probably the most likely of scenario. As I mentioned before, DEA is never not followed in HHS recommendations. So it's probably likely that cannabis is going to be rescheduled from Schedule 1 to Schedule 3. That's going to have some significant impacts across the board. It really isn't going to affect too much the question that we're talking about today, which is employment protections. It could for federal employees. So if we have anybody on the seminar today that is they're federal government employees, or they work for the federal government, rescheduling could affect those folks directly. Take a minute here. I mentioned before in 2018 that industrial hemp is now legal. So there's a distinction there, right? So this slide is meant to kind of show you, they're basically hemp and marijuana, they're cousins, for lack of a better scientific term. The chemical compounds that really, when we start talking about this, and we're going to talk about this in more detail today about THC, we're going to talk a little bit about, we're going to do a little chemistry, we're going to talk about carboxy THC, we're going to talk about hydroxy THC, but really what we're talking about here are cannabinoids. These are these chemical compounds, and there's hundreds of them in the cannabis plant. CBD is a cannabinoid that is non-psychoactive. THC is the cannabinoid that is psychoactive. That's what gets you high, quote unquote, right? Under the 2018 federal law, essentially the line is 0.3% THC by dry weight or less is now legal. That is hemp. And anything above that would be still illegal. Currently Schedule 1, right? So that would be marijuana. So as a reference point here, as this slide shows, 0.3% is tiny, tiny, tiny. 15 to 20%, if you were to go into a medical marijuana dispensary today, most of the products there are going to be somewhere in that range. So it's by order of magnitude much more of this chemical compound that's psychoactive. We just kind of went through CBD. CBD oil really is kind of what we're talking about here. That's the most common form, but you can also get it in creams. There's ointments. You can buy it on the internet. You can go on Amazon right now and get CBD oil. The one final thing I'll say about this for now is it's supposed to be regulated. CBD is supposed to be regulated by the FDA and the FTC, which are two federal agencies. The FTC deals with mostly advertising, consumer protection. So that would be the agency tasked with making sure that what you buy on Amazon is actually legal, that the labeling is accurate, and the FDA would be trying to basically regulate this. They're not doing a great job, bottom line. So you could still get a vial of CBD. Who knows whether it contains whatever the label says it's going to contain. That's the takeaway for employers. And we've dealt with employers in the past who kind of come and say, what are we going to do about this? Because we drug test folks, they come up positive and then they say, well, it was CBD. It wasn't, I don't take, cannabis. I don't take marijuana. I would take CBD. So we'll talk a little bit about that at the end in terms of best practices. One final thing before I turn this over to Carolyn, until we get into California and their new law. Just a note that DOT covered employees, you still are following federal law with respect to this. So even if you're in one of these 37, 38 states that have medical marijuana, or if you're in one of the states that has also recreational marijuana, that and you're in one of the 9 states that has recreational marijuana that has off-duty protections. Every one of those states, even if you're in a state that has statutory employment protections, they all have these carve-outs, essentially say the same thing, that you don't have to violate federal law. And so if you have an employee, let's say they're a commercial, they have a commercial driver's license, or they're a truck driver, and they would be subject to DOT Part 40 testing, you're still following DOT Part 40. None of these state laws that we've been talking about and that we are going to talk about today would, obviate your need to comply with Part 40. And you can go ahead and comply with Part 40 and drug test these folks, and take whatever, employment action you need to take in accordance with your DOT Part 40 policies. Okay, with that said, I'm going to now hand this over to Carolyn, and she's going to talk about AB 2188. Take it away, Carolyn.
Okay. Before we jump into the new statute, let's review the state of California in terms of the cannabis laws. So as Kia mentioned, California was the first that passed the medical use of marijuana, and that was back in the mid 90s. 20 years later, California legalized cannabis use across the board for adults. So that is the game, that's the playing field that we are in now. And it's been a very fascinating journey to watch as cannabis law and regulation has developed over the last 30 years. And so the 2188 and then its correlate SB 700, which changed the government code section 12954, was passed and is now the way in which the state of California views cannabis in the workplace. So next slide. So this slide is basically just summarizing when cannabis can be used in California. It's legal if you're an adult, 18 or older, with a physician's recommendation, or 21 or older as a personal use item. And various cities and counties may have stricter laws, but that's the general tenor. And then, of course, you can use it for medicinal purposes. Next. Okay, and so there additional information on when you can use cannabis. So you can use it on private property, but not in public places. You can't smoke cannabis where it's illegal to smoke tobacco, and you can't smoke cannabis within 1,000 feet of a school daycare center or youth center while the kids are present. So all very common sense and practical stuff that everyone knows. So now we get into the part where employers are kind of trying to understand where they fit in all of this. And when I look at this statute, I find that the legislature's findings in the reasons for why this law was passed is very useful for employers to keep in mind, and it will help guide them in what they will do in terms of compliance with this law. The first finding is that the legislature found that metabolites, that THC metabolites, do not necessarily indicate impairment, and that's the findings, like where you have a test, somebody smoked marijuana 30 days ago, and yet they are still testing positive for THC metabolites. The second finding that the legislature discovered is that the intent of drug tests is to identify employees who may be impaired. So the key for purposes of cannabis in the workplace and trying to regulate it is to ensure safety, basically, and to make sure that people are not impaired and that we have a drug-free workplace. And then finally, the legislature, when it looked at this issue, concluded that a lot of alternative tests exist to measure an individual's impairment on the job, including the reasonable suspicion tests. And then there are increasingly better and better tests of bodily fluid tests that can identify the presence of THC in bodily fluids. So those were what the legislature concluded, and after many years of studying this situation. And so it came up with this law, 129954 of the government code. And that went into effect on January 1st of this year. And basically, 12954, the new 12954, it mandates that employers cannot discriminate against a person's use of cannabis off the job and away from the workplace, and cannot discriminate based on some drug screening test that has found the person to have non-psychoactive cannabis metabolites in their urine, hair, or bodily fluids. The legislature was very practical in its approach. Basically, if you are in the building and construction trades, which de facto are safety sensitive, the adverse employment action discrimination, anti-discrimination provision does not apply. It also exempts applicants and employees in positions requiring a federal background investigation or clearance by the Department of Defense or equivalent regulations by another federal agency, such as the DOT, the Department of Transportation. And also the legislature specifically says that this anti-discrimination law doesn't preempt state or federal laws requiring applicants or employees to be tested for controlled substances as a condition of employment for receiving federal funding or federal licensing related benefits, or entering into a federal contract. So, for example, you might have a federal contract with the Department of Defense in which you are required to test your employees, or maybe they're engineers on a nuclear sub, for drugs. So you would be following that contract, that federal law, and the government code 954 wouldn't apply. Next. So 2188 was passed in 2022. That's when the governor signed it. And it was to go into effect on January 1st, 2024. In the meantime, last year, the Senate Bill 700 was introduced to as a correlate to 2188, and it's just specifically deals with the applicants for employment. So just to make sure that everybody understood that we cannot discriminate against people who use cannabis off duty. You also can't ask about it during a job interview, and you have to be very careful about obtaining the information about prior cannabis use and criminal history. Don't just automatically terminate just because they have a history of maybe an arrest or conviction for marijuana possession, for example. So I'm going to pass it on to Ashley, who will now talk about a similar law that was passed in Washington State, and it's similar to California's with very minor differences.
Thanks so much, Carolyn. We wanted to share just a little bit of information about this Washington law with everyone, because it is very similar to what was passed by California recently. It went into effect January 1st of this year, just like the California law. But there are a few differences, which kind of highlight for all of us who have employees in multiple states, the challenges of keeping up with this evolving situation of states passing these laws and how they are slightly different from one another. The Washington law makes it unlawful for an employer to discriminate against a person. Here's the kicker. Here's how it's different than California. In the initial hiring of employment. So we're really talking about kind of those decisions to hire an applicant as an employee, as opposed to California pertains to both hiring and once somebody is actually employed by a company. So it's discriminatory in the hiring process to make that decision to not hire somebody based on their use of cannabis off the job and away from the workplace, or, and this language is very similar to California, an employer requiring drug screening that tests for non-psychoactive cannabis metabolites in the hair, blood, urine, or other bodily fluids. Very similar to what Carolyn was talking about for the California law, the Washington legislature found that the legalization of recreational cannabis in Washington in 2012 created a disconnect between prospective employees' legal activities, so their legal use of cannabis, and employers' hiring practices. And they went on to say many tests for cannabis show only the presence of non-psychoactive cannabis metabolites. So what doesn't actually impair you from past cannabis use, including up to 30 days in the past. And that has no correlation to an applicant's future job performance. Similar to California, the Washington law does have some critical exceptions that employers should be mindful of. First, the use of scientifically valid drug screening conducted through methods that don't screen for non-psychoactive cannabis metabolites are allowed. We're going to talk a little bit more about testing very, very soon and what that means. Employers are still allowed to maintain a drug or alcohol-free workplace. If employers have rights under federal law or regulations to test employees in the pre-hire process, that is still allowed. And here's what's interesting. The Washington law says employers can go ahead and do kind of the full panel of screening for controlled substances, even pre-hire, so they can go ahead and do that. And test for marijuana that screens for non-psychoactive cannabis metabolites. If they do so, though, the employer has to basically instruct the testing company not to give them those results for the marijuana portion. We thought that was kind of an interesting nuance with the Washington law. And then obviously, post-employment testing is still allowed under the Washington law. There are exceptions for certain positions under the Washington law. So basically, if you think of any position where it's kind of a safety sensitive position, you've got first responders, police officers, fire department personnel, airline, aerospace workers. If there's a federal government background, the investigation or security clearance role that requires drug testing, that's allowed. Interestingly, for the safety sensitive positions, this law says employers have to basically identify that it is a safety sensitive position in advance of hiring that position. So, making sure to identify this as a position where there is an exception under the Washington law. And then
I'm sorry, Ashley, I just want to kind of, on this topic of the safety sensitive carve outs, it's interesting too that, that's more specific and has a more robust safety sensitive carve out in California, right?
Right. Yeah. Yeah. It's more specific in that it specifically says, you're right, Kia, that it's for positions in which impairment while working presents a substantial risk of death. So that is definitely more specific. And so that is also kind of an interesting nuance from the California law.
Yeah, and I do feel that it is useful to look at this Washington law and other laws, whereas the various government bodies are struggling with this issue and trying to provide rules for bringing together the fact of the legality of cannabis, the fact that you're not necessarily going to be impaired even if with metabolites that are detected in your blood, and then at the same time, making sure that your workforce is safe. So all of these different ways. And so I think it's very useful to look at the Washington law and its more specificity, because it'll give you ideas for your own workplaces as to how to assess this particular issue.
This is something that we'll continue to talk about this afternoon after we talk about the specifics of the Washington law. But it's also, I just want to underline this and kind of, parrot what Ashley and Carolyn just said about this. Each state has a different take on this, right? So, and we'll get to this at the end with some of the questions that we got before our presentation today. For example, if you have somebody that you might consider to be safety sensitive, just in your own vernacular and your own understanding of what safety sensitive positions are, doesn't mean it's going to be exempted out from these employment protections. You probably have a greater chance of being exempted out under Washington law, for example, than you would in California, because California, it specifically talks to building and construction trades, but there is no kind of general safety sensitive carve out there. And
Right.
if you remember the slide I showed you guys in the beginning with all these 20 different states that have, for example, employment protections for medical marijuana users. Well, maybe roughly half of them have a safety sensitive carve out, the other half don't. So another example would be, for example, in New Jersey, there's no safety sensitive carve out there. So it really depends upon where you are and where your employees are located. So with that, I'll let Ashley finish up with Washington.
Great points, Kia and Carolyn. So just to wrap up some of the more nuances of Washington law, it does make it clear that the Washington law does not preempt, meaning if there's an existing state or federal law that requires an applicant to be tested for cannabis, then you follow that existing state or federal law, and you ignore this new Washington law in that situation. And it makes it clear that also includes if a business is receiving federal funding that requires an applicant to be tested for marijuana or cannabis, federal licensing related benefits, and then also federal contractors. Now, again, the key here, as written under the Washington statute, is if the federal or state law requires an applicant to be tested for controlled substances as part of the contract, to receive the federal licensing related benefits or to receive the federal funding.
Yeah, and this is similar to California.
Right. It's a good point, Ashley. They have
Yep.
to, the law or the regulation has to require these folks be tested. So it's not necessarily enough to say, oh, we get funding, so therefore we should be able to continue to do the drug testing that we've always done. You have to actually look and go further and determine whether or not these applicants or employees are required to be drug tested under some federal scheme.
Exactly. So this leads into, practically speaking, given what we know now about the new California law, maybe the new Washington law applies to some of your workers, how are employers supposed to navigate this landscape? Just kind of stepping back and looking at how employers are implementing drug testing amongst their workforce, right? So we've talked about Washington's law is specifically targeted at that pre-hire drug testing. And by the way, we want to make sure to emphasize this is kind of good employment practices. We never want to be doing drug testing or screening of applicants before they receive a conditional offer of employment. So we're talking about that post offer of employment but before they begin employment. So we've got kind of the pre-hire screening. We've got reasonable suspicion. Some employers have that as a policy. Obviously, post-accident, that is usually a part of an employer's policy and procedures, is to send somebody for a screening when an accident occurs while working. And then obviously we've got some employers who implement a random or a periodic screening, especially if employees are working in a safety sensitive or a security sensitive position. So in analyzing kind of all of these, and I want to be clear there, we saw kind of a question in the chat just a few minutes ago. You know, yes, the Washington policy is focused on that pre-hire drug testing, but the California's law is not limited to pre-hire. So California's law actually would cover all of these different drug testing scenarios that an employer might be implementing amongst its workforce. Now, keep in mind, right, we've got kind of our policy where we might be testing folks. And we've talked, Kia's already highlighted this, these two laws that we've talked about today. The intent behind the law is establishing or recognizing that drug testing does not necessarily prove that somebody is impaired by cannabis at the time the testing occurred. And so how do we navigate that? Okay, if you could kind of go to the next slide, we're just going to talk a little bit more about the science here. And, you know, after using cannabis, the body, you know, metabolizes THC into what's called 11-hydroxy-THC. And that's the part that makes somebody impaired. That's the part, the psychoactive part, so to speak. And that's the part where somebody's, you know, feeling the impact of ingesting cannabis. Generally speaking, for many individuals, that 11-hydroxy-THC will be out of the blood system in about 6 to 8 hours. What happens at that point then is the body metabolizes that into what's called carboxy-THC. Carboxy-THC is the waste product from ingesting cannabis. It's inactive. It's not making somebody have kind of the physical symptoms or effects of being high. And our bodies store that in fat tissue. We eventually get rid of it through urine. And it can be detected in urinalysis drug testing long after impairment of that 11-hydroxy-THC. It's tough right now because it's still a Schedule I controlled substance. There have not been a lot of scientific studies on how long marijuana is staying in individual systems. Generally speaking, there is more and more research being done, but it can depend on so many different factors: gender, genetics, weight, how often folks are ingesting marijuana. There is some findings or suggestions that there can be kind of a resistance or a buildup with respect to kind of, you know, people feeling kind of that high impact, but then, you know, maybe that carboxy-THC is staying in their systems much, much longer because they're a frequent user of cannabis. So drug testing based on urinalysis test for that carboxy-THC. So when we look at both the California and Washington laws, what we're concluding based on that is employers really should not be using the urinalysis test for cannabis for their workers going forward in these states, because it is testing that non-psychoactive metabolite. So what are kind of the alternatives here?
Yeah. Ashley, before you kind of move off that point, I'm glad you made the point you just made, because we've been talking for about 15 minutes and we've been throwing around that term non-psychoactive cannabis metabolite, right? And because that's the wording that the California legislature chose to use. And then I think I'm correct, right, Ashley, that Washington aped that. They used that phrase, right?
Yes.
Non-psychoactive cannabis metabolite. So just so everybody's clear, this slide that Ashley's been kind of breaking down the chemistry for us, non-psychoactive cannabis metabolite is carboxy-THC.
Right.
That's that thing that binds into our fat cells and hangs out for up to 30 days, maybe 45 days if you're a super duper heavy user. But that is what these statutes have said, no bueno. You can't simply just use that. We had a question in the chat, which we were going to kind of get around to this anyway, but I'll address it here. You know, depending upon what state you're in, it kind of depends. Does that mean you can't use the drug test at all? Can you use the drug test in combination, maybe with observations, for example? You'll probably be, in a better spot if you do that. And Ashley's going to talk now about, observations and some best practices around that. But generally, I would say, without looking at a specific client or employers, where they are, where they operate, what they do, generally, and this is what I usually tell folks, you're talking about now we're transitioning into a period now where more and more states essentially you look at it like drug test plus. And the plus is something else, observations. If you remember, Caroline talked about California statute and the legislature talking about impairment tests, talking about baseline, measuring an employee's ability to do certain tasks as a baseline measured against what they could be doing if they're impaired at work under cannabis. So what does that look like? So we'll talk a little more about that, but I just wanted to underline that point that this is really important. This slide is probably the most critical slide today to understand what California and Washington are doing and why they're doing it. It's because when you take a urinalysis test, which is by far the most common, drug test screening panel that you're going to use today in the United States, what you're getting when you have somebody testing positive for cannabis is carboxy-THC. It is a non-psychoactive cannabis metabolite that doesn't have anything to do with whether that person, was actually impaired at work. So with that said, let me get to the next slide here. I think we kind of covered this, Ashley, but
Yeah.
Yeah,
I can jump back in. So and just want to, I think somebody had said, can we repeat that? So I just want to be really clear. What we're saying and what we're recommending is under this new California law, testing using a urinalysis drug test for cannabis is no longer okay. That is not allowed under the California law. In Washington, same thing if you're doing the testing for pre-hire and you don't fall within, and in both of these states, I should say, and you don't fall within one of the exceptions. So we want to be really clear about that. And getting to this slide, it just kind of reinforces this point about how long marijuana or THC can be in the system long after impairment. And it kind of compares to other types of substances that employees may or may not be ingesting. I want to touch on, before we go to the next slide, Kia, just briefly kind of other types of testing that employers might be implementing. One test that we've started considering, and there's been kind of a lot of discussion about when we're talking about this area is what's called oral fluid testing, which is basically a fancy term for saliva testing. And there are some studies suggesting that perhaps that type of testing could be testing for the psychoactive metabolites. So therefore, it could potentially be allowed as a test under both the California and Washington statutes. We, though, are a little nervous because there hasn't been anything with authority in either of these states that have come out and confirmed that these tests would be allowed and sufficient. And also kind of the science behind the, the claim that these tests for psychoactive metabolites is in question. Again, this is an area where there just hasn't been a lot of testing, scientific studies and testing. Practically, too, we want to make a point. The oral fluid testing is very expensive, especially when you compare it to how much urinalysis drug testing costs employers. So practically, if you're dealing with a large workforce, the oral fluid testing may not be a good option for you as an employer. This kind of highlights the guidance that we're providing to employers in California and in Washington. And he already hit on it, observations. So if employers, even if employers think, well, we're going to try the oral fluid testing, we still recommend that, observations are going to be critical here for determining whether your employee is impaired while working. There's kind of like a step-by-step process that we've been training and coaching our clients on in making these observations of impairment. We obviously want to make sure that observations are happening in the moment, that there's firsthand accounts of somebody who might be impaired by cannabis on the job. We should be talking with the employee directly and making those observations. Are there any smells? Now, smells are a little tough because somebody could have ingested marijuana a couple days before coming into work and wear the same, sweatshirt, and that smell is still on there. That doesn't in and of itself necessarily mean that somebody is actually impaired at work. We want to look at, their eyes. Are they dilated? Are they bloodshot? Are they watery? Is the employee wearing sunglasses inside? Speech patterns, they seem slurred, their coordination's off, they seem super slow or, just not themselves. Maybe they're being careless, they're not following the normal safety protocols or processes, which is a problem in and of itself. Any unusual behavior, sleepiness, on the job, or even, maybe somebody observes them, taking a nap on break, plus there's some other things going on that have been observed. Excessive sweating, clamminess, nervousness, or seeming very excited. And then just kind of seeming sick or dizzy, fainting. All of these could be symptoms of being impaired by cannabis. We ideally want to try to get these observations of impairment by multiple people, right? Not just a single individual, but multiple people. And then ideally by some sort of manager or supervisor or even human resources who can kind of back up like, yes, this person seems off. This person seems like they are impaired. Once that kind of impairment observations, and I think we've kind of covered these kind of side effects. Once kind of the impairment is being observed, we highly recommend documentation of those observations in the moment. Again, it's critical. The timeliness of all of this is really critical. Have a form ready. We've been working with clients. We actually have developed an observation of impairment form, and it's somewhat easy for managers and supervisors to go through. It's got some boxes. It's got short lines where they can write in the observations of what they're seeing, but it has to be documented. Usually this is coming up because maybe there was a workplace accident or somebody complained about behavior. the details matter. We want it to be specific. Email's a great way too. If you don't have a form to fill out, somebody approaches you as somebody in senior management says, I think this employee's high. I think they're on something, maybe marijuana. Have them write an email of all of the observations and be as specific as possible. Generally speaking, as employment attorneys, if it's not in writing, it didn't happen. It's very, very difficult for companies to defend whatever actions they took with respect to an employee if they didn't put it in writing. We also recommend that employers really make sure that their managers and supervisors are trained on this area. Right? Update our policies and procedures, put our managers and supervisors through the training, both on, okay, what are symptoms of somebody being impaired at work? How do we identify that? How do we make sure we're kind of identifying that and not just creating issues and targeting folks who are totally fine at work? And we want to make sure the training is happening often, right? That it's regular, that we're doing it with some sort of regular cadence. And then finally, with kind of best practices for employers, we want to update our written policies. We want to review our drug testing policies to make sure that in light of these new laws in Washington and California, that we don't have an outdated policy that talks about, we do urinalysis, reasonable suspicion testing for all of our employees. We just really need to make sure the policies are up to date. Some employers, and we get this a lot of employers, and I'm interested in talking, and hearing what maybe Kia or Carolyn have to say about this. Some employers have kind of gone the route to say, well, we're just not going to test for marijuana, period, as kind of their solution to this. And we don't necessarily think that's a good idea for most of our employers who have employees in positions where if they were impaired, it would be a big deal, right? So Kia, I don't know if you wanted to weigh in on that a little bit.
Sure. Yeah, funny enough, probably the state that I would get that question, the most from is California, even before 2188. For years now, we've had clients, and I think it's because marijuana has been legal in that state for so long. You have such a large proportion of the population that, just does it recreationally, and it's not a big deal culturally. So, so I would have clients saying, well, we can't hire the people that we want, like, because we have these policies and we have, a drug testing policy. And so, can we just ignore our policies? My answer to that is no, that's a terrible idea. You want to follow your written policies. To kind of just piggyback on what Ashley just said in terms of best practices. You can review your policies and you can update them and you can change them, but don't not follow what your policy says, because then you're opening yourself up to, for example, a discrimination claim, right? So follow your policies, but again, what can we stop testing in California, because I can't fill the positions that we need to fill. So that has been a common refrain that I have definitely seen. And now in light of 2188, I'm sure we'll get that question, much more often. Should we just, for example, stop screening, altogether for cannabis? I tend to agree with you, Ashley. I think it really just depends on what your business is, what your company does. Whether or not that would be a solution for you, practically and, culturally sometimes too. I hate to generalize, but, a lot of our clients in the South, the Southeast, they culturally, that's not something they want to do or even signal. So, I think it really just depends, whether or not your company and your organization wants to just go ahead and suspend, testing for cannabis. But certainly now, if you're in California and you have to deal with 2188, just to be clear, you can't use that drug test positive to make an adverse employment action. And Ashley, I'm glad you you kind of underlined that before. When I said drug test plus, that's a general proposition for most states in the country. California, now you can't use the drug test. You can use the plus part, but you can't use the drug test part. So, and that also, I want to also just bring up something Ashley said in connection with Washington law about the fact that they've woven into their law that you can still screen for cannabis on a pre-employment drug screen, but you can't, you should not get that result from your third-party provider. And that's something that, your organization, even if you're not in Washington State, you could consider that as well. That's a smart thing to do if you are in a state like California. So let me make clear, California law, and Ashley and Carolyn, you can correct me if I'm wrong, California law doesn't prohibit you from testing for cannabis. Like, you can still do it. You just can't make an adverse employment decision based on it. So if you want to go ahead and for whatever reason, continue to do your 10 panel or whatever panel you're using, because it's just easier administration wise, it would probably be smart to coordinate with your drug testing provider to say, but I don't want to get those, I don't want the cannabis results. Even though you can get it under California law, nothing says you can't get those results, but you can't make a decision based on it. Well, what if you don't want to move forward with this candidate for some completely other reason, a different reason? You can do that. But what if you get sued then under 2188 or, some type of theory, public policy theory, and it says, hey, no, whatever reason you're giving is pretext. This was really about the positive test. So my point is it could be smart to rethink that, work with your third-party providers, work with your drug testing screening agencies to come up with, what's going to work best for you. I know we're kind of we're running out here a little bit. Oh, let me give everyone the codes.
Yeah.
And we have a couple minutes left too. So we did get a few other questions on the chat.
I wanted to jump in. I saw that question on the chat. Carolyn, I'm going to put you on the spot. There's a good question here that said, well, if California legislature determined there are tests that will indicate impairment. So, right. So there are tests that measure the psychoactive metabolite. What are those tests? Carolyn, do you want to jump in and address that one?
Yeah, well, the legislature hasn't prescribed something specific. Like, for example, if you are DOT regulated, there are specific labs you have to go to and specific protocols you have to follow. The California legislature didn't do anything like that, but they did have a finding that, and this is the social engineering that's going on behind this statute. It's meant to put employers in a different frame of mind, because previously, after the California Supreme Court ruled in this case called Ross versus Raging Wire, basically that somebody who had tested positive on a drug test in the workplace, regardless of whether or not he or she was high, could be fired because it was a violation of federal law. Okay. And it was a very simple rule to follow. And many employers followed that for many, many years. The legislature is telling employers, hold on, don't just make these snap decisions based on a drug test. You need to, because the point of all of this is whether somebody is endangering people or themselves because of their use of marijuana. And so you have to think of it from that practical aspect. And the legislature had determined too that impairment can be determined in various ways. It could be done by observation, and what Ashley went through is a reasonable suspicion test that's been around for many, many, many years. And so the legislature is encouraging employers to use that. There's breathalyzer. There are lots of different tests out there, and I saw the question about breath testing. Yeah, and there are a whole bunch of them out there. I mean, the thing is the science isn't there, and you can speak with your testing agencies that you use to get the latest on the science piece of things. But my understanding, and correct me if I'm wrong, Ashley and Kia, is that there is no like breathalyzer test for alcohol, which can tell right away that somebody is actually drunk, right? That is not the case for THC and THC metabolites, as Ashley had explained previously on that with the science slide.
Let Ashley.
If I, yeah, I would love to jump in. Carolyn, you're pretty right. There are companies out there that are frantically trying to develop a cannabis breathalyzer, which is a wonderful idea, right? If it does indeed work similarly to the alcohol breathalyzer that a lot of us know, that has passed some scientific rigor and challenges, legal challenges. But you know, the breathalyzer test, I've actually seen a demonstration of one, and they're really interesting. The problem is, because all of this is new, you know, these two laws are new. We haven't gotten guidance from the legislatures or even court interpretation of these statutes. We just don't know if these states are going to say, yes, there's enough scientific kind of backing that says, yes, the breathalyzer is testing for the non-psychoactive, pardon me, for the psychoactive metabolites. And so because we don't know this with any sort of certainty at the moment, we're advising our clients to take a kind of a more cautious approach and not just rely on that product. Now, if you want to implement breathalyzers because you've talked to these companies, they've done some research and testing, and you feel like this is a good avenue, what we suggest is that, as Kia mentioned, the plus, right? Let's do the observation as well. And then that way, if the test itself is challenged, you've got your backup documentation of, well, but not only did this person's test reveal X, but here are the observations of this person and why we think they were impaired on the job.
Yeah, I wholeheartedly agree with that, Ashley. We're not there yet with breathalyzers. One final thing I just wanted to, just go back real quick to that question specifically about, well, if the California legislature said there's other ways to do it, what are those ways? And Carolyn, I agree with her answer. I just want to point out too, and this is something that, she said in her original presentation, and also Ashley talked about it, but I'll just kind of underscore that again. They do specifically, not only do they mention impairment tests, but they do talk about bodily fluids. So they don't say it, but we kind of figured that means saliva testing, right? And the problem with saliva testing, expensive, not as readily available, but I guess that depends upon your provider. For example, I know LabCorp is advertising it right now, but also scientific reliability around that too, because we don't even have any federal labs in the country yet that have been federally approved for saliva testing under the DOT Part 40 protocols. I think Ashley mentioned this. Last year,
Yeah.
on June 1st, finally, the Department of Transportation gave the thumbs up for DOT Part 40 employees that would be subject to DOT Part 40 to do saliva testing. However, you can't do it yet until you have 2 labs that have been approved by the government. And as of, I think it was January 4th of this year, the latest Federal Register basically just said, we don't have it yet. So that doesn't mean that if you're not subject to DOT Part 40, you can't do saliva testing. Obviously you can, but if you are subject to DOT Part 40, you can't do saliva yet because we don't have any labs that have been approved to it. And my thought process around that is, again, if you're in California and you want to say, let me try to get around 2188, let me go with saliva testing. You could probably do that, but just to kind of echo what Ashley just said, we don't have any guidance. We have nothing from the legislature. We have nothing from, basically anybody yet, no courts, of course. And can a plaintiff's lawyer make the argument? Well, that saliva test is not reliable. They haven't been approved. They're not a federally approved laboratory. The argument back would be, well, they don't need to be, but it's just stuff that I think are going to get thrown against the wall by the plaintiff's bar. So that's just one other consideration. And on the final note here, impairment tests, which is the other thing that the California legislature said you can do. Nobody knows what that means, right? So I'm based in New Jersey. We have different laws here, but we have this concept of a WIRE, a workplace impairment recognition expert, that's built into our adult use statute. Nobody knows what that is either. And we've been spinning our wheels on that for over a year. Does that look like, field sobriety tests where, you touch your nose and you do all that kind of stuff? We don't really know. So when the California legislature says, hey, science has improved, everyone, good news, there's all these alternative tests, quote unquote, that are out there. I think that the question that we got saying, what are they? It's almost like, good question. We're not quite sure what they are. We know that there are, there is saliva testing. There are these types of impairment tests, these human performance tests that maybe you can consider doing. But it's something that you have to give more thought to. You should talk to, legal counsel, of course. You should talk to your testing providers. I think the one thing that we hope that you all take away with from our presentation today is there's a lot to think about. And, you got to look at your policies, consider training, consider policy decisions. What do you want to continue to do? What makes the most sense for you? But there's a lot to think about, and you should not just simply assume that you can continue to do things as you did before. So with all that, thank you, everyone. I'm sorry we went a few minutes over, but for those of you who stuck around, I hope you found it useful. And Victoria, I'll send it back over to you.
Thank you all for joining us today. We will now end the webinar.